Attorney broker John McConnin here, and welcome to my California Residential Purchase Agreement and Joint Escrow Instructions. Now, let me just say, over time, this was the video that got the most views on my channel, and I would get calls from buyers and sellers sometimes off this video. Now, this is an updated contract, massive changes, as you would expect, given all the class action suits last year. But let me go over the preliminary things that I got a lot of positive response from in the past. So first of all, the comment that I got the most calls about, or always mention the calls. Thank you for pointing out to me I should be using the most recent contracts, because now I always look up there to make sure they're the most recent, because as I've said before, if you don't know why you're not using the most recent agreement, that's a mistake. It's like that saying, if you sit down at a poker table and you don't know who the sucker is, it's you. Well, if you're using these C.A.R forms and not using the most recent ones, you could be getting played. Because there are advantages built in some of the other ones. I expect that happening less this time than in the past because of the way buyer agent compensations changed so dramatically. But just be aware, because it's not always, it could be a listing agreement, it could be other things. Make sure it's the most recent one, unless you know why you're not using it. Date prepared, this is date prepared. Date signed would probably be the date of the agreement, but you can identify it sometimes by saying date prepared and signed, just in case there was a multiple offer situation and you're a listing agent, you're talking to your sellers, or you're an attorney reviewing them. This next thing is stunning, because the buyer would write their name in here, or the buyers would write their name in here on the buyer line. But where's the seller line, right? The first time I reviewed this in a transaction, I mean, I'd seen the forms as C.A.R was preparing them and sending them out, but I hadn't been really looking at it as if I was going to use it or review it for a client. The first time I reviewed this for the client, I was going through here and I was like, I don't see the seller. And then I did it again, and it took me 3 takes. I was like, and then I immediately spun. It's a bunch of pages, and I spun to the end, and I saw, yes, there is indeed a seller's block and a seller entity identified at the back end of this agreement. But it's no longer shown in the front here. And I think this is for multiple reasons. One, I always wondered when I was preparing these for buyers, if, especially when dealing with trusts, and sometimes I do work with lawyers or selling things for trusts, and I always wondered, what if the buyer names the parties wrong? And then escrow comes in and says, we got to redo this. Like, does that mean there's not an official contract? Does that mean that time periods for disclosures run, or any of those other time periods reset? Could this be an out? Let's say a new offer came in that was much stronger and the party wasn't properly named. I mean, it seemed like there's a lot of liability on buyer's agents to get this right, and they're not even attorneys. Like, how do they know what the proper entities are? So I think it's my view as of July 2025 that if I'm working with a buyer, I'm not putting in the names of the entities of the sellers. I'm letting the people I'm sending this offer to, especially if it's on the MLS, the agent that I'm sending it to, I'm letting them deal with it. Now, I don't think the listing agent should be dealing with this either, necessarily, if it's a corporation or an entity. I think the seller should know, and the seller's lawyer, but as a listing agent, you better be very careful. Let's put it that way. Now, another reason is, and I get this as an overall sense, that this was set up to remove a lot of the pre-negotiated risks that listing agents in buyer's agents, basically the collusion risk, the class action lawsuit risks. This feels much more like the buyer and the buyer agent are doing the work here, and the listing agent and the seller are the people offering their property for sale. And there's much less going on as collusion. I don't even mean that in a pejorative sense. There's much less going on like, oh, agents working together, confirming these things on the MLS, like compensation. It's already said, it's a it's a foregone conclusion. Here's this little section. It's not really part of the contract, but we're going to make sure the buyer's agent gets paid. Like, that's missing now. It seems like it's more, hey, this is how a buyer working with a buyer's agent can make an offer on a property, right? And That's a significant change. It's a significant change to the feel. Now, we get to this seller's brokerage firm, buyer's brokerage firm. I mean, if you're using an MLS, if you've done this on the MLS, I think you can probably put this in, but it's no longer that important because it's not like the listing agent's the one offering buyer agent compensation. They certainly shouldn't be. Like if I say we're offering 2 or 3% and I'm representing a seller, I've made a mistake because it's the seller offering the money, not the listing agent. I still catch myself when I'm working on another sale right now, and I had a listing a couple months ago, and I had to catch myself and prevent myself from saying things. And in fact, that's why I got an AI to answer the phone for me. I wanted the AI to set the amount of buyer agent compensation we were offering straight in very consistent manner, because I knew I'd say we. So, it's not as important, because if you're doing this right as a listing agent and a seller, you're not the one offering buyer agent compensation. It's the seller. And it's the buyer who's going to be eliciting it. So the buyer's broker's firm. Now, we're going to cover this section quickly. And then just to keep these videos the right length, the next video we're going to cover the major changes because of buyer agent compensation, what's going on in that box. But in this box, first of all, let me just say this is great because all the variable information are now in these blocks. Pretty much in the whole contract, right? I've never been a big concern. The lawyer in me has never been all that concerned about initials, as long as you can keep the contracts together well, which is usually not a problem with PDFs. I suppose those initials matter at times, but I've never been concerned. So really, all the variable things are in those blocks, which is a fantastic change, because that allows, like I used to have to go through the contracts and circle and pull out the information and write them down to compare things for clients, especially multiple offer situations. And now, most of the things that can change the variables are either this offer block where you talk about the seller, buyer signatures, and acceptance. It's just in the end here. So like the contractual formality things. Otherwise, well, liquidated damages is always an issue. Arbitration is an issue. But it's really nice to compare. As I had like 13 multiple. Back in March, we had 9 active at any given time, but I think we're up at like 13 total. And it was easy to explain to my seller when they call up and say, well, where are the best ones and how are they different? And compare and contrast all of these in these blocks instead of having to go through and scoop them out was great. So let's just finish this page, and then we'll go to the next video. We'll talk about buyer agent compensation. So here, purchase price, obviously. Close of escrow, write it in. Expiration of offer. Here's a tip. If you're a buyer and it's multiple offer properties or well-priced properties or properties that people are, maybe fixer-uppers, that there's going to be demand. I've sold properties for clients where they've said, go ahead and draft up the counter, or, they've agreed on the phone, let's get this drafted up, and the buyer's been back drafting the contract with the new terms. In the meantime, new offers come in. So if you're making an offer, and especially if it's your second offer, you might want to put the date in and just say 5 p.m. to not give them overnight to find a new buyer, right? Put some pressure on them, because you can always renew it the next day if they didn't sign it in time. Deposits, loan amounts, I would say if they're not secondary, it's not primary, if they've checked secondary investment, you want to spend even more time on interest rates. When interest rates are changing rapidly, you want to make sure there's a cushion or a buffer there if you can. Purchase price, down payment. Now, this next section we're going to cover right away. The very next video, we're going to talk about the significant change to these contracts, and that now it's the buyer who requests buyer agent compensation. And I've had lots of videos on this, but I'll cover it, what sellers should do about it. And then I'm going to go over a third video. In terms of the philosophy, you have to understand that these contracts are set up to give lots of buyers outs. They're designed to encourage buyers to make offers. And in the second video after this, I'm going to talk to you about how to tie down those outs. Not just the normal way realtors do it, but ahead of time, so that if it's a slower market, or there's fewer offers, you're not giving buyers time to shop your deal and try to get a better one or hope a new one comes on the market. So we're going to talk about the 8 or 9 buyers outs. There's 8 plus other outs. We're going to talk about what a smart seller would do in the second video. The very next video, I'm going to go through this and probably finish the review of this contract. My name is John McConnin. So this is the California RPA Part 1. You should look for Part 2 next.